have just an hour and 10 minutes to discuss about the subject which we are discussing for years. And that simply means that we will not finish. But before the start of the cocktail, which we are dividing you from, we are going to take the panel of the title, The Regulation of Global Data Flows. A story of impossible? Ladies and gentlemen, dear colleagues, that's my pleasure and honor to meet you here with the wonderful panelists with enormous experience in the field of privacy, data protection, and the flow of data, with a little bit provocative title of the panel. We added the question mark in the end, which is also important. It's possible, or is it impossible, to regulate the flows of data? Can we even talk about the flows of data? Something which we thought is flying and which is moving its position is actually right now in global interoperable infrastructure, and sometimes these are only the changes of the access rights, which we are talking about, not the real flow of data. But we have to remember, as I heard that Achim Klabunde has recalled it in the previous speeches, that the GDPR is not only about the protection of the personal data. In the very title of this regulation, there is also the free flow of data. And it is on invite to find ways to make the governance of the data flows more meaningful, more efficient, and more protective. The COVID pandemic and the war in Ukraine, and more generally, the very troubled political situation, geopolitical situation worldwide, are a bitter reminder that there is a need for more convergence and cooperation worldwide, in particular with these regions that share the same fundamental values of democracy, of human rights, and of the rule of law. Free and stable international data flows, free and stable exchange of information should ensure the very high level of data protection. It is likely to constitute one of the main challenges for the nearest future. This debate about the balance of free flow of data and the meaningful protection of the individuals is not new. It is with us for some decades, actually since the first data protection laws start to be created. We all know that at the moment it's somehow excessively covered by the discussion about only transatlantic direction. But we are talking about the data flows all over the world. We all know that Safe Harbor and the Privacy Shield agreements did not stand the test from the Court of Justice of the European Union. As regards to transfer to US, we now need a long-term solutions. This might perhaps come in the relatively short period of time. On 25th of March 2022, the Commission and American friends informed about the political agreement on the principles of the new framework for the transatlantic data flows, but no legal solutions have been revealed so far. We may probably hear about them soon, but we still know that there is a political agreement on that. As a new agreement is likely to be challenged, once again, at the courts, it is very clear that any new deal will have to provide sufficient guarantees to widespread protection. This being said, I hope that this panel will be an opportunity to broaden the debate and to consider the regulations of data flows in a more global perspective. That's why we chose the specialists who are coming from different continents and who can help us to look not only to this transatlantic direction, but also to the work of OECD, Council of Europe, Global Privacy Assembly, G7, G20, and to explore the possible long-term solutions that could satisfy, from the European point of view, the high standards of the data protection as they are in the European Union Charter of Fundamental Rights. Many interesting questions deserve further discussions. As adequacy decisions are long and time-consuming process, what can be the expectations for the facilitating of the data flows between the EU and the rest of the world with other means? The Schrems II ruling will inevitably result in enforcement by data protection authorities of the EU and in some bans on certain transfers. Is there an inherent contradiction between the data sovereignty and the data localization? And the push for the free flow of data in the digital world. I don't like the notion of data sovereignty. Everybody who heard my bad words about data sovereignty know that the problem of localization and of so-called sovereignty on the data is in the middle of the discussion of the data protection authorities. What can be the multilateral solutions? Can certification or the codes of conduct give another impetus to the work on the data flows? How can we create more trust and convergence between the respective jurisdictions? As I said, what is the role of the international organizations? What is the role of unofficial forums like G7 or G20? And are there the possibilities to include the solutions which exist in other regions in the discussion in Europe? Can we somehow combine the very different ideas of Asian and Pacific countries and the European ones? Is the Japanese proposal to create the large area of trusted flow of data really promising? So it's my pleasure to introduce the distinguished speakers today, who will first tell you their point of view on the whole problem, and then we will go to the debate also with the active participation of the audience. Ms. Vera Jourova, Commissioner of the European Commission and the Vice President of the European Commission for Values and Transparency. Vera Jourova was always very connected with the EDPS, and I always remember your speech at the summary of the last strategy of EDPS in 2019. Anna Brian Nugreres is United Nations Special Rapporteur on the rights to privacy, and also our long-time friend at the International Conference of Data Protection Commissioners. At the same time, she represents the Latin American approach to the cooperation on international level. Ulrich Kelber is the Federal Commissioner for Data Protection and Freedom of Information in Germany, and one of the leading figures in the European Data Protection Board. But first of all, he's the person who has to present the opinion of 17 data protection commissioners in his country of origin. Well, 18 because you count yourself as well. Yeah, because 17 land commissioners, but of course, also the whole framework of the data protection in Germany. And I have big honor to host the debate with Ulrich Planck, head of the Digital Economy and Policy Division in OECD. And the role of OECD in data protection has gone far away beyond the guidelines that were on the market for years. And finally, Professor Graham Greenleaf, Professor of Law and Information Systems from Australian University of New South Wales. And I have to admit personally that before I started to work with data protection, Professor Greenleaf was my idol in the legal informatics, what we call law tech at the moment. Well, each speaker will start with short intervention, and as I said, we'll then go to the discussion. Ms. Commissioner, the floor is yours.
Thank you very much. Good evening. Yes, Mr. Viborowski, I remember that event. I was criticized for making too many jokes about data privacy. I will be very serious today. People should take lessons seriously. And this is a serious topic because with growing digitalization, we see that more and more we will have to see, watch, and protect the data privacy when they travel. And in the EU, we have a very strong rule that the right of people travel with their data. It sounds easy. It's not easy to do because when we see the massive flows of data, for instance, the United States, but many other countries, how to guarantee that the data, private data of Europeans will be protected in the same way on the other side of Atlantic or somewhere in Asia. And the European Court of Justice made clear that when data of people travel outside Europe, there must be essentially equivalent protection. And GDPR enables us to lead the negotiations, rather the talks, leading to the so-called adequacy decision when we find out that there is that sufficient protection in that third country. And by having this rule, by having strict rules, thanks to GDPR, I am sure we can be self-confident and certain to remain open for the data flows. So if somebody says that there is a contradiction between the free flow of data and the data sovereignty, or some call it European new protectionism, I have to reject it because these two principles are very much complementary. We can enable the data flows when the rights travel with the data, and at the same time we can use data for European economy. And the third principle, we will always be vigilant on regarding all the actors who want to operate on European single market, that they respect and apply fully GDPR rules. We have several adequacy decisions now in place. The new one with Japan, South Korea, the newest is with United Kingdom. Now we try to do the damage control after Schrems 2 and to create a new system with the United States so that we can have the guarantee on the other side of Atlantic that the protection is there. And the United States, of course, it's the special category, only taking into consideration the volume of the data, massive volume of the data, which travels every second there and back. And the data flows to America are also important for European businesses. So I remember when I was working on Privacy Shield on the basis of Schrems 1 decision, which suspended safe harbor, I had in mind, of course, first of all, the privacy principles or protection of privacy as the first principle, but also the need of data flows for economy, also for European economy. we had to look into the American system on the access to data from the national security bodies. We were looking into whether the Europeans have sufficiently strong system to complain against data abuses on American territory. I was convinced that the Privacy Shield was well designed, was strongest possible mechanism, but the European Court of Justice had another opinion, so they suspended it again, and now we are working on a new system, and I can share with you some parameters of the new one in case of interest. I was personally very involved in fact, I was negotiating the EU-Japanese data flows system, or the adequacy for Japan. It was an interesting exercise because Japan had at the time very similar law to GDPR. But what was missing was the very strong enforcement line. And I was insisting that they need to have comparable bodies with data protection authorities as we have, because I kept insisting somebody has to enforce it, somebody has to go after the breaches, somebody has to sanction. And they didn't understand me fully, because they said when the law is in force, the people and the companies will respect it. So I realized the cultural difference, that in Japan they do not have the tradition of such a strong law, enforcement line. But at the end of the day, we agreed on some mechanism. With United Kingdom, it is a special one. We have this adequacy decision with the sunset clause. After 4 years, we will assess whether UK didn't deviate too much from GDPR and whether there is still that essentially equivalent protection. In case they deviate earlier, today, tomorrow, we can suspend by unilateral decision anytime. So this is the mechanism. Mr. Wieworowski spoke about how to arrange things in global scope. I am very proud when I hear from many that GDPR serves as a global standard. I think that we should be stronger in data diplomacy, creating some kind of global network of adequacy partners in the future. It was already started by Japan, who wanted to create this World Data Flows with Trust initiative. And I think now with new US administration, we are better ready to have better reactions from the US side. I go to US at the end of June, and I will check in the Congress and among the stakeholders the air, the atmosphere, whether there might be some kind of GDPR of United States, the federal law, but it doesn't look like that. I know I speak too long, so few comments at the end. GDPR is the set of rules which serves as the basis for many different subsequent rules for digital age. You had a very interesting discussion here about artificial intelligence. We came relatively late with regulation because we were sure that the GDPR is in place and that we can take some time to set the rules right. Also, GDPR served as a strong basis for our work on Digital Services Act and on the regulation on political advertising, because here we use the systemization of data, which we have in GDPR, and the definition of sensitive data, and we say that sensitive data like religion, sexual orientation, some other kinds of data must not be used for micro-targeting when it comes to political advertising, because this is too dangerous. We do not want these bubbles and this manipulation which is abusing the access to private data before every elections in the EU. So just to mention GDPR in its multiple role as the basic fix or basic system we have in the EU. I will stop here, but of course I am available for your questions. Thank you very much.
Thank you very much. And I would like to ask Anna Briand to present the point of view of the new rapporteur for privacy in the UN. You had the opportunity to meet the previous one, Mr. Kanatachi, at the earlier stages of this conference, but Anna has a long experience of work in the continent which was somehow looking at what's going on in Europe, but created its own approach to the data protection, even if Uruguay is the member of the Convention 108 and it's the most influential country, I can say, in the continent so far. Anna. Should be on.
Can you hear me? Yes. Yeah. Good afternoon to all of you. I would like to begin by thanking the European Data Supervisor for his invitation and the organizer of the conference for making it possible for us to be here sharing some reflections on these topics with all of you. Thank you very much. So, is the regulation of global data flows a story of the impossible? Perhaps it is. As you know, there is no global agreed regulation on international data transfers, and there is a lack of coherence in the different data protection systems that have, as a consequence, problems in interoperability schemes. What is the reason of this lack of regulation? Two reasons come to my mind, and I will mention them as a way of inviting you to reflect on them. The first one, data does not have a standard value. Of course, I admit the need of respect for the diversity of the people. I also understand that privacy and data protection are intrinsically involved in the culture of the people. And cultural aspects can be quite different from one point to other in the globe. We might need to work this out. The second one, the digital divide. In fact, the digital and technological development of the countries, so different, imposes a diverse way of facing data privacy and international data transfers. The asymmetries between the responsible of the database and the data subject do not help either. The challenge, always, is to build bridges towards providing clear international guidelines on how to protect privacy and data protection, and to ensure that dignity, equality, and freedoms are protected. Of course, the final motto should be to enjoy the free flow of data in the digital world and to enjoy, too, at the same time, of a strong data protection system. A model data protection system seeks a healthy balance between the protection of the fundamental right of privacy and the free circulation of goods, persons, services, and capital, while ensuring a healthy economic and social integration. Speaking of a strong data protection system implies not only regulation, but also the existence of remedies that will act when there is no compliance with such regulations. Different regulations show a general law, sets of principles, systems of certifications, accountability obligations. These are all different ways of focusing data protection and international data transfers. The examples are in the GDPR, in the Ibero-American Standards for Data Protection, in Apex CBPR, in the dispositions of modernized Convention 108. Some of them present the free flow of personal data only between parties, with exceptions. Others present international data transfers only if certain conditions are met. In general, all these systems present regional solutions to international data transfers, but we need to assume that their global application is not as easy. To face global solutions in international data transfers implies to reach standards of cross-bordering data flows, and to reach that goal, certain elements are important. For example, the recognition of digital signatures, of electronic signatures, the validity of contracts, online consumer protections, authentication, the prevention of unsolicited personal communications, the prohibition of data localization requirements. Summarizing, building trust between consumers, businesses, government, academy, experts. We need to reduce uncertainty online, especially for vulnerable populations, the economically disadvantaged, racial and ethnic and sexual minorities. We need to standardize data flow rules and principles. We need to integrate other stakeholders, actors in the process of conciliation between e-commerce and data protection. We need to promote openness, transparency, and accountability in all processes. Creating trust is paramount, as only trust allows data to flow. Creating secure environments harmonized with privacy is of the essence of these systems. It is impossible to achieve good levels of privacy if there is no security of the information. Only in the case of well-secured information we can achieve data protection. In what refers to timeframes, there is no estimate of a time frame, as this depends on political, social, economical contexts that operate locally, regionally, globally. Now, to work in terms of cooperation towards global harmonization on privacy and data protection systems is one of our priorities as Special Relator for the UN. We feel we must work towards the implementation of standards in which integration and harmonization in the global context are achievable goals based on ethical principles that guarantee respect for the diversity of all peoples. The regulation of global data flows is one of the aspects of this whole. We believe it is possible. I would like to finish my words inviting you with Paul McCartney's words when he says, "We can work it out." I'm sure we can work it out. Thank you very much.
Thank you very much. One of the organizations that started already years ago go to the practical solutions in data flows was OECD, with the guidelines which we have already for years. And OECD was very active last years in promoting the more global approach to the privacy. Audrey Plonk will present us the point of view of the international organizations.
Thank you. It's really nice to be here with you all. Thank you so much for having me on the panel. Before I talk about the current state of various projects we have, I thought I would give a little bit of a primer on how we think about data from economic terms at the OECD in order to answer the question a bit more of, is this possible or impossible? Because I think the truth is that we're still at the very beginning of discussions about how to regulate data flows, how to put policies in place, how to put governance structures in place of what will be a very long trajectory of developing regulations and policies around what the universe of data flows. And it's not exclusive to privacy and data protection, but it includes many other disciplines across computing that are important, for example, security, intellectual property rights, other topics. We're here today to mostly talk about privacy, so I won't go there. But just to say, one of the challenges with regard to data is that from an economic perspective, data is non-rivalrous. It means its value for you is not the same as the value to the person next to you. It can be decoupled, it can be aggregated, it can be shared, it can be sold. And the price that you pay for a set of data is maybe not the price that it cost the aggregator or the provider to build the system that collected the data. And so when you look at statistics and numbers about how important data is, I would venture to say right now we're not totally sure what we're measuring and what we're looking at. And I raise this at the beginning because it makes it really difficult to understand how to put good policy in place if we don't really know the impact either in terms of economic or social or whatever dimension we want to measure by. And so I raise that because the process to getting to a place in which we can understand better the value of data and how to measure it is a long one. It's one in which if you look at the time it takes to develop statistics around GDP, for example, we're at the very beginning of trying to understand data flows and their contributions to, for example, GDP. We know it's big, but we don't know how big, and we don't know which basis to measure. Are we measuring a bit or byte? Are we measuring how much a service provider, a cloud provider paid to build a system? We don't know what we're measuring. So, or everybody's measuring something different. So that is a process and a plan that we have to work very hard to do. It's unglamorous. It's really not it's not as sexy as some of the stuff like European Court of Justice rulings and whatnot, but it's very, very important to get the long-term regulation right. And so that's why in 1980 and for the last 50 years, the OECD, or 40 years, the OECD has built on the privacy guidelines that were mentioned by several of my colleagues here. And in 2013, when we last reviewed the privacy guidelines, this idea of privacy and data protection interoperability really started to become a basis for discussion. And I raise that now because I think in a lot of contexts, what we're talking about is how do we make our various approaches at a national level or at a regional level interoperate with other national or regional approaches to protecting data and privacy if we don't all follow a particular legal standard or subscribe to a particular set of specific policies. And so the OECD is kind of a microcosm of a context where you can look at what 38 different countries are doing at the national level and see like-minded countries that are rule of law democracies with free market economies behind them to see different approaches. And you see that even within those 38 market economies with the rule of law and democracy behind them, there's not a homogeneous approach, and that has led to a lot of debate, concern, and desire to advance a more, dare I say, interoperable system between which we can share data around the world without compromising on privacy rights, individual freedoms or liberties, and without unduly impacting the economy, which brings me back to my first point in that it's hard to know what that impact is right now. So we've taken a few different approaches over the years. First is obviously to continue to monitor how countries implement the OECD privacy guidelines. Suffice to say that they are a fairly baseline standard that almost everybody uses, but also to build on those guidelines in a couple of different ways. One is in the recognition that data, in order for them to be valuable, either economically or for social good, they need to be able to be accessed and shared, and that there aren't frameworks in which to do that. So we've developed what we call a recommendation on how governments can put policies in place that better enable the access and sharing of data within privacy protecting environments. So that's one recognition that we have to be able to share data if we're going to get value from it. The second is that there are emerging areas like national security and law enforcement where once distinct worlds that used to operate sort of in their own silos are really merging together now, where we see in the context of Schrems, but not exclusively, that there is an increasing desire to have more transparency around what law enforcement and national security agencies do with regard to accessing data, particularly held in the private sector, and that inconsistent approaches can decrease trust. And so that's where we sort of enter this concept of data free flows with trust, which it's been championed by Japan, but I think really gets at this idea that we're not going to do everything the same way, but we need to find ways to make the different things that we do interoperable so that we can work together to reap economic and social benefits from data. But again, I think we're at the beginning of that journey, and it's way, way too early to say whether it's impossible or possible. I mean, I think at the beginning of any journey, you don't go down it if you don't think it's possible. So I assume we're all here because we think it's not just possible, but an imperative for growth, for well-being, to solve the next pandemic, to get a better education for children all around the world, for a number of good purposes. But we also recognize the real danger and threat to personal civil liberties and privacy, and we don't want to give that up, and we shouldn't. And so the work that it will take to get us to a place where we can maximize those benefits, minimize the risks, I think we're at the beginning of that. And it's not, again, just a question of can we all adopt a single privacy regime, but a question of how do we make an interdisciplinary set of economic and social factors work together to enable those data flows. And I think that's the perspective we bring, a little bit broader than just a European perspective, but also still a smaller perspective than, say, colleagues in the UN. So thank you very much for having me.
Thank you very much. When you see Ulrich in the panel, you would like to ask about the German approach, you would like to ask about EDPB, but we shouldn't forget that Germany has also the presidency in the G7. And G7, despite the fact that there are 3 countries who are following GDPR directly in the G7, that was Japan who took the privacy to the subjects of the discussion. And it's still not sure if the G7 is the point to discuss the subject.
Yeah, dear friends of privacy, dear Wojciech, thank you for the invitation and the opportunity to take part in the panel. I would like to contribute to the debate about, with a brief intervention on the implementation of the Schrems II ruling by the EDPB and the national supervisory authorities, and also have a look on the work of the Global Privacy Assembly and the G7 on the topic. With the ruling of the European Court of Justice, work has become more complicated, far more complicated, with the increase of complaints and with the increase of the asking for advisory by authorities and by companies. The data protection authorities in the European Union are faced with almost similar cases, and that's a reason it's important to take a coordinated approach on the legal assessment as well as on enforcement. The EDPB is trying to establish guidelines and recommendations, and in addition to that, the board seeks to achieve coherency in the assessment of cross-border cases in the European Union. In the context of the Schrems II, especially recommendations on the supplementary measures, and in combination with that, the new standard data protection clauses by the European Commission have given a significant contribution to the practical implementation of the requirements of the Schrems II judgment. However, the current situation cannot be considered satisfactory. The legal situation in the US, and we heard that when we have been at the Global Privacy Summit in Washington, hasn't changed now. There is still the unproportional access, governmental access to data, the lack of the access to remedies for European citizens and the lack for independent supervisory authority. I hope that there will be seen necessary legal changes in the upcoming successor scheme for the privacy shield, like Commissioner Jourova has outlined. This would be an important signal beyond the transatlantic relationship. I'll come back to that. In the event the EDPB, and that's the role of the board, will closely examine the new transatlantic framework in order to determine whether the possibilities of governmental access, of independent authority, of the possibility of remedies will be installed in a compliant way, so no one of us, neither the Commission nor the board, will face another decision by the European Court of Justice that the regulation will be not compliant with EU law. And that leads me to some remarks to the main topic of the panel, so the international regulation of international data flows. There is a de facto global data space implemented by the use of services cross-border case with some more influential countries and their digitized industries. And so if there is such an international data space, we have to keep the pace of regulating that on a common legal principles at international level. And there are a number of international organizations working on that. We heard about the OECD, the Council of Europe with the Convention 108 Plus, or the APEC Global Cross-Border Privacy System, which has been shown by 4 members, but we will see much more countries participating on that. And I'd like to mention the GPA and the G7. The GPA, with its 130 members, is not an international organization, so it can not adopt binding rules, but it's a fora for discussing the very ideas, the schemes of legislation and the technological enforcement on that, and can advise national authorities. So the GPA on its last meeting in October adopted a resolution on government access to data, showing that the 130 members have a common understanding of what is necessary, which is proportionate, and how citizens may have a chance for legal remedies on that. The G7 presidency, the Japanese brought in 2019, I think, the idea of this data free flow with trust, and our colleagues from the British ICO brought that to a level with the G7 roundtable of the data protection authorities of the 7 member countries and some invited friends last year. And the German presidency is continuing this work on the government level. So we saw that meeting of the G7 digital ministers, I think 2 weeks ago, with their with a declaration about the democratic values in international data flows, and with their work on an action plan for promoting data free flow with trust. And part of this will be an ongoing dialogue with the data protection authorities in the roundtable. It is important to further advance at international level the idea of data free flow with trust. And with a conclusion to that, to have a look what that means in that area, especially from the European perspective of Schrems 2. If Commissioner Jourova will be successful in that, and everybody supports that idea, we will have adequacy decisions of the European members and the European Union with all other G7 countries. So we have would have a kind of a G7 data space at that part, but it's at the first time limited to G7. And the idea is how to, if we had that success, to go further and have to have a more global common space. So there is alternative systems to the EU adequacy decisions, like the CBPR I mentioned, with the 4 countries and together with some others like Taiwan, Korea, Philippines. The aim is to build a certification for companies, a self-standing global certification scheme to facilitate trade and international data flows. There are obvious differences between these both scopes. So on the one side, a supranational legal order based on fundamental rights, so like the GDPR and its adequacy decisions, and a voluntary certification scheme based on agreed standards. And both of them are on the market. Both of them had for the same idea of having an understanding where trust for a global exchange of data, but they are in a, not only on a supportive market, but also on a competition on the ideas behind that. So coming back to the title of the panel, I would not sign that the regulation of global data is an impossible mission, but there is enough work to do to find a common ground for it.
Thank you very much. Professor Greenleaf knows probably the most in the world about different approaches to privacy and data protection, specializing in informing us about the new developments in this field all over Europe, but also having quite critical approach to these developments. Professor, could you please tell us, do we probably have the act that can stand as the building point in the Convention 108 plus?
I'd like to get to that. Commissioner, if my slides are now available. I want to take up the conundrum you've set for us and try to answer what do you mean by this being an impossible problem. And
can we have the presentation of Professor Greenleaf?
Sorry? Some reason I can't get the slides to move forward.
Do you technical support? Can we have the presentation of Professor Greenleaf?
I'm sorry about this.
Okay.
Yeah, okay, good. And in answering this, I want to start by looking at what do we mean by this being an impossible problem by looking at the size of the problem. And the place to start, I think, is that there are 157 countries now that have data privacy laws. And on my estimate, 80% of them, or about 130, make data exports from one country to another at least partially contingent upon the state of the law in the other country, either adequate, equivalent, at least as strong as, etc. Now, the GDPR removes the bilateral problem in relation to 30 EU and EEA countries, but we're still left with, in theory, a problem of something like 100 by 130 or 13,000 different possible data export questions. Can you export data from South Africa to Argentina, from Australia to South Korea, or vice versa? And even if you reduce the size of the problem just down to the 30 countries outside Europe with the highest GDP that have data privacy laws, you're still left with something around 800 different combinations of data export issues. And after 40 years of having international data privacy agreements, we have made very little progress in reducing the size of this problem. So, where can we start? And I suggest that we start by making it a two-track solution. First, consider that the question of the transatlantic problems, the EU to US transfers in particular, is being solved by the current state of adequacy determinations, of which the Transatlantic Data Protection Framework will be the most recent, and we can trust that the combined attentions of NOYB and the Court of Justice will provide a reasonable solution. Then we have the sort of the rest of the world problem, and my suggestion is that what we want to try and do is use basically network effects to reduce the size of that problem. Now, why isn't the problem of so many different data export combinations reducing? We do have standards high enough for global trust. That's the good starting point. Countries that have been assessed as adequate under the GDPR, or if you like, under the directive. Countries that are parties to Convention 108 plus, or will be once it's in force. They're the high enough standards that most of the other countries in the world are happy to live with. But unfortunately, there are no mechanisms in our current instruments to implement the trust that we would have. EU adequacy only provides free flow from the 30 countries of the EU and the EEA, and not even from the other countries that have been judged adequate by the EU. And in relation to Convention 108 plus or 108, there's no guarantee of any free flow of data at all in those instruments. They're not self-executing. Now, many countries in their laws can institute or enact white lists. Data protection commissioners or governments by regulation can create a list of countries to which there can be free flow of data with no restrictions, similar to the adequacy model. But the point is they don't do it. Deciding who is in and who is not in the list is too politically sensitive for most countries to want to take that on. And the costs of thorough assessments and updating those assessments periodically is also too high. So it doesn't happen. So what we need is to find some solution for default white lists, in my view, that remove that problem from the individual countries concerned by effectively allowing them to outsource the issue to the institutions that are making those decisions anyway, the European Commission and the Council of Europe. And so I come down to saying that while trust is basic, it needs networking to really be effective. We can set out a list, as I've done there, of 3 trusted bases for data exports to be allowed. To the member states of the EU and the EEA on the one hand, because they're bound by the GDPR, to countries with a positive adequacy assessment from the EU, and for parties to Convention 108 plus. But the point is that any country, even if they have no connection with the Council of Europe or with the EU, can add to their laws a default whitelist provision which will expand as the number of adequate countries expands or the number of parties to Convention 108 expands. So gradually, the number of problems of data exports that we don't know the answer to will reduce as these white lists are created and the adequacy decisions expand and the parties to 108 plus expand. Now, I won't go much longer because we only have a few minutes each. The theory behind this is basically just a simple bit of networking theory, that network effects are where an increased number of participants in some system raises the value of a good or a service. And our problem is we have too few network effects in the data export problem. But if, as set out in the 3 steps here, if you have an increase in the number of default whitelists, that will increase the value of EU adequacy decisions or 108 plus accessions to countries that are so recognised by the EU or the Council of Europe. That increase will then act as an incentive for more countries to seek adequacy decisions or accession, and that expansion will increase the value of the existing default whitelists and be an incentive for other countries to enact them. So it's your classic virtuous circle. Now, it sounds perhaps unlikely, but the nice thing about it is that there are at least half a dozen countries that I've found, and I'm sure there are more, this is not thorough enough, that have enacted exactly that type of default whitelist arrangement. And those default whitelists, small, the number of countries though it is, already authorise data exports in over 250 situations of exports between different countries. So I'll stop here, but just on the note that all of the international organisations represented in this panel could take steps, some of which I've listed here, to increase those network effects and thereby reduce the number of data export problems that we have in all the rest of the world countries. And it would be a small but valuable part of the solution to data export problems if that occurred. Thank you very much.
Thank you very much. Bearing in mind that we have 11 minutes to the end of the session, I propose first start with the questions from the audience. And if we will have a time, I will ask some other questions to the panelists. We have the first question there. Can we in the middle of the room?
Yes, Theodore Christakis, Professor of Law at the University of Grenoble-Alpes and European Director of Research for the Cross-Border Data Forum. Thanks for a fascinating panel on such an important issue. I just have one question for the 3 European members of the panel, which is the following. One of the main issues discussed during this panel is what should be the standards that we should follow. So Mr. Kelber mentioned the European Essential Guarantees guidelines of the EDPB, which is a very important document. I was just wondering, as an academic, if EU member states meet the theoretical standards that we find there or not. What we are asking to the United States, for instance, we are asking for redress, not only for compelled access, but also for direct access, for foreign intelligence, for direct access outside the boundaries of the country. Do we find this in Germany? Is there a law providing for redress for outside the country, for foreigners? Do we find this in France? If not, is this of a concern for you? How could this change? Are we into a logic of first we take Manhattan, we have the US doing this, and then we take Berlin? We will find a way for European countries to follow. Thank you.
First part of the answer is that secret services in Germany are less different to other countries because they don't have that, they have to share the things they may do with the police. That's a historical development. But yes, latest after the last ruling of the German Court of Justice, there's equal right for persons inside and outside Germany, for German citizens, European citizens or German citizens, and non-European citizens. And even the Secret Service, the worldwide Secret Service, has to look out for that proportionate access and for the possibility for legal remedies to that. And independent supervisory authorities, not only one, but 4.
We had discussion on this subject after 2013, where I would like to remind you the European Parliament was inviting the representatives of the member states to present how this kind of oversight looks like. And the results were different, but we have to say that the development in Germany, especially after 2017, was incredible. Do you want, Commissioner, also to add something?
Yeah, of course, when I hear about the access to private data from the national security bodies and secret services, I always remember the American reactions when I was pushing them to give us more information what are their safeguards against the mass surveillance. And we saw that the safeguards are not sufficient for us, of course. And I received the questions, and how do you do it in Europe? Do you have it under control as the Commission? Of course not. It's for the member states, because this is the national security field. And I have to say that I would be quite certain that in the EU member states, everywhere they respect the principle of necessity and proportionality for the access to private data, and judicial control and judicial redress. Why I would be satisfied or certain, because now when we look at the use of the Pegasus spyware for surveillance, I have to say I am very nervous, because we hear from the member states where this spyware was used, by the way, against the journalists or against the political opposition leaders, in Spain against the members of the government. So it has several different features. So I have to say I hear that this is covered by the national security competence, where the Commission has nothing to say or nothing to do. But I have to say that I am not satisfied with that, and we are looking into what we can do, because I see at least the fundamental rights angle, I see the protection of the media angle, and I think that we simply have to bite this bitter piece, yeah, and discuss whether we can say like that this is the national security issue and just to give up. It's not my plan.
We have another question here from the two ladies, then the lady two rows.
Thank you very much for your valuable insights. I'm Maria Saluste from the European University Institute, working on international data flows and international trade law. And as the title of this panel is the regulation of global data flows, and mainly we're focusing on privacy. However, if you allow me, I think it's important to mention that data flows to some extent are regulated under the General Agreement on Trade in Services. And there's even an exception for privacy, meaning countries are allowed to regulate privacy if they follow certain requirements. And I think it's just important to highlight that there is a certain framework also on transparency and everything that does give some guidelines for all the international organizations to follow and to take into account. So as there wasn't a mention of this, and there are also e-commerce discussions at the WTO, I think it's just important that the international organizations will work together, and the European Commission, of course, is taking this into consideration as well. Thank you.
Thank you for this commentary.
Good afternoon. I'm Christina Irion from the Institute for Information Law in Amsterdam. I would like to ask a question about the economic approach to measuring data flows and its contribution, and how economists can actually take account of the value of data protection in the transactions and electronic commerce, and in essentially how you want to measure something like trust and how that will get into the equation, because I'm a little worried when economists are getting to work that exactly this aspect is hard to pin a number on and will be then not visible. Thank you.
Is there anybody who wants to start?
The short answer is I think we're a long way off. I think what we're trying to do is understand or start to build indicators around trust. And so you're not, you're probably not going to have one indicator. The community has, I think, for many years been resistant to to building up quantitative measures of how privacy contributes to X, Y, or Z, because you start to say, what are you going to look at? You're going to look at how well funded your data protection authority is. You're going to look at how many cases are brought and enforced against. You're going to look at how much cross-border cooperation happens. And then countries will say, oh, but that's not fair because my country is different than your country, and we're smaller, so we shouldn't have to give them as much money, or we had less cases, so the enforcement. So there's a lot of work behind the scenes from a methodological point of view that we're trying to undertake to bring not only some rationale to what would those pieces of the puzzle be, but also politically to get countries willing to let us go down that path, because it's very sensitive and has been historically sensitive. So that's one piece. Which is sort of gets to your question about trust. With regard to the economics of data, there's different ways to measure it, and there's no one right way. It's just important to know that you're looking at different things. So you can measure bandwidth, you can measure how much data are flowing across in terms of bits and bytes. That's hard to do in an aggregate internet way, but if you talk to providers or ISPs, you can sort of get something. It's not comparable, but you can get something. Then you can look at the approach taken by national statistical offices is, well, there's various approaches, but the one that the economists at the OECD and the economists from all our member countries have agreed to take is what we call a sum of costs approach, which looks at, well, it sounds like you're an economist, so maybe you know, which if you're a technologist and you read about a sum of costs approach to measuring data, you sort of go, I don't know, they had to convince me that this was the right way to go about it. So that's going to give us something. It's going to give us an indicator of investment into infrastructure. It's going to give us an indicator of what salaries look like, how much people are spending to create data. And so we're going to have to get a picture of a bunch of different things that is not just, data is this value at the end of the day, because it's non-rivalrous, because your value is going to be different than my value.
And hereby we came to the end of the time for this conversation. I propose to continue it during the cocktail, which we are just starting. The European Data Protection Supervisor is happy to be again in the real world conference of on data protection, and CPDP is still alive. So also our session is alive. Please join us in the next room. I will address the organizers in a while from the top of the building. Thank you for our panelists. Thank you for all those who survived the very tropical